First off this week, the Supreme Court has ruled that the plan to send asylum seekers to Rwanda, where that country would decide whether to take them, is unlawful. The chances of a plane taking off before the next election are, according to the lawyer Adam Wagner, pretty much zero. We'd love to know what Nigel Farage thinks of all this, but sadly, he's sweating in 40-degree heat in Australia for I'm a Celeb, and he can't tell us. Alex, first things first, why did the justices find this unlawful?
So this was the third round of legal knockabout on this policy, basically. The High Court found it unlawful. The High Court found it unlawful. It was appealed to the Court of Appeal. That was a split judgment. One of the justices thought it was lawful, and so it went up to the Supreme Court, and this was now the definitive judgment on the matter, unless the government decided to appeal to the ECHR, which would just make me pee myself with laughter. They won't do that. And it was a 5-justice panel, and it was a unanimous decision. It was a much quicker decision than expected. And I'm saying all this because it is important, because everyone thought maybe it'll be a fudge. They will say the scheme is fine, but not Rwanda right now. Maybe it'll be a split decision. Basically, that some sort of hope would be dangled the government's way. And it just wasn't. It was a crushing verdict from the court, with Justice Reed making a point of listing all the reasons why it was unlawful and making sure it was understood that this was not just down to the European Court of Human Rights, the European Convention of Human Rights, I should say, but it was down to several domestic laws and down to several other international conventions to do with the rights of refugees, to do with the rights against torture, to do with international conventions on trafficking. So basically the signal he was giving to the government is, if you think that leaving the ECHR will solve this issue for you, it won't. You will basically just have to leave the planet, leave the international legal system in full. The core of the judgment is this principle against non-refoulement, which stems from very old French laws of war, basically, that meant if a serf was between the two lines of army advancing and was trying to get behind the lines, because it's like, this has nothing to do with me, gov, you weren't allowed to refouler, to push them back into the action, as it were, into the war zone. And so what is important to say is that non-refoulement is considered by most legal scholars to be what is known as a jus cogens, which is a peremptory norm of international law. It's something that you can't amend in some ways, or interpret in some ways, or curtail in some ways, or circumvent in some ways. It's basically an axiomatic value that all parties to international law accept and you cannot move from. And so I think the anchoring of the decision in that is, it means basically the Rwanda scheme is dead.
So fundamentally, this is about not being able to trust Rwanda not to send people back to their countries of origin, isn't it?
Yes. And considering the circumstances that the judges listed, even though they left the door open, they said, of course, there is some point in the future where maybe things would move in a way that would allow us to think of this as something that could happen, which is something judges always do in a matter of policy, because they don't like to tell the government you can never do this. But it's not doable. The government's response has been to say we'll upgrade this memorandum of understanding into a treaty so that it has more legal force. But, considering one of the judges' reasons for saying no to this was that the rule of law in Rwanda is not respected habitually, and there are things like extrajudicial killings and people disappearing in the middle of the night and people being deported without due process, I'm not sure that a treaty would suddenly make them think, oh, that means all of that is all right. And it's also significant that it was the UNHCR that was the primary evidentiary contributor to the court. They're the people that gave them the evidence. And what the court said is, look, we looked at what you say, we looked at what Rwanda says, and then we looked at what this
they actually
international organization that we all belong to says, and we decided that we kind of believe them.